Good morning, ladies and gentlemen. It is 10:05. And pursuant Article 11.2 of the bylaws, as Chairman of the Board of Directors, I take the chair of today's extraordinary and ordinary shareholders meeting and declare the meeting open. With your consent, I call upon to serve as Secretary Notary Carlo Marchetti. I would ask the notary to provide with the consent of those present the information necessary to be able to declare today's meeting properly constituted. Thank you, Chairman. We have adopted electronic voting system using remote device with the intention of reducing time taken for counter operations. If there are technical problems in relation to voting will be carried out, of course, by a show of hands. I believe it is necessary to provide those present with the necessary information on the correct use of the remote device delivered to all of you at the time of registration. Now, the Secretary will show a short video explaining how to vote using the remote device.
Gentili azionisti, vi chiediamo soltanto alcuni secondi di attenzione per guidarvi all'utilizzo del sistema di radiovotazione. Questo è lo strumento che oggi utilizzerete per esprimere la vostra preferenza. Il vostro radiocomando è stato personalizzato tramite una chip card che non deve mai essere estratta. Premendo il tasto I quindi di voti associati al vostro radiocomando. All'apertura della votazione, il display evidenzierà il numero della votazione stessa e il messaggio votazione aperta. Da questo momento in poi potrete esprimere la vostra preferenza premendo uno dei tre tasti superiori. Potete modificare la scelta appena effettuata premendo un tasto differente. Infatti soltanto dopo aver confermato con il tasto OK il vostro voto verrà registrato in maniera definitiva e sul display del radiocomando apparirà il messaggio voto registrato. Quando verrà chiusa la fase di votazione, tutte le preferenze raccolte verranno elaborate e il risultato sarà calcolato automaticamente. Vi ringraziamo per la vostra attenzione. Per ulteriori informazioni potete rivolgervi al personale presente in sala.
So we will ask you to cast your vote using this specific device. So you may vote for being in favor, against, or abstain. So the call notice for the meeting was published in full on the company website on 3rd of June 2016. As well as on the same date, a summary was published in the following newspapers: Sole 24 Ore, English version on Financial Times. Agenda is as follows: extraordinary session planned for the reorganization of Snam's equity investment in Italgas SPA, and in particular approval of the plan for the partial and proportional demerger of Snam SPA required and consequent resolutions. Ordinary session authorization to purchase treasury shares. In addition to Chairman, Chief Executive Officer Marco Alverà, Sabrina Bruno, Yu Peng He, Lucia Morselli, Elisabetta Oliveri. Also attending, Leo Amato, Chairman of Board of Statutory Auditors, and some statutory auditors coming. Some directors and or statutory auditors we haven't mentioned are absent for justifiable reasons. Boschetti Stefania, Formetta Massimiliano, Corbetta Guido, and Zazzi Fabrizio are also present, representing auditing firm Reconta Ernst & Young, appointed to undertake the independent audit of the Snam annual report, consolidated financial statement as at 31st of December 2014. We'd like to inform you that the share capital is 3,696,851,990 4.00 euros divided into 3,500,638,294 shares without part values. And I would like to inform you that over 2 billions of shares represented 69.4% of the voting capital. Moving forward, Pursuant to Article 13 of Legislative Decree number 106 of 2003, Code on the Protection of Personal Data, the personal data of those attending shareholders' meeting were and will be requested in the forms and within the limits connected to the obligation, tasks and purposes set out in current law. And they might also be disseminated and communicated abroad in the forms and within the limits connected to the obligation. The list of names of those entitled to attend the meeting on their own account or proxies, indicating the number of shares held by each and the delegating shareholders appropriate, is available to attendees and accompanied by a list of the names of any person arrived after or left before each vote, indicating the shares held by each will be annexed to the minutes of the shareholders' meeting. Before each vote, the number of participants in the voting procedure in doing so will be communicated, and then the outcome will be announced. I would like to inform you that as CONSOB recommends, financial analysts, journalists and qualified experts will be enabled to follow proceedings of the meeting. As per Article 5.2, Chairman's Office has been established. Marco Reggiani, Secretary of the Board of Directors, assisted by Stefano Spezzagni. You should know that system of the audiovisual recording the proceedings in operation in the room with the purpose of assisting preparation of the minutes. That he will be recorded with a 5-minute delay with due precision. Pursuant to Article 4 of the regulations for the meetings of the shareholders, not recording devices other than the stated nor photographic could be used in the premises. Also, simultaneous translation from Italian to English is available. Of course, headsets are available at reception. As per Article number 7, requests to speak may be submitted to the Chairman's Office from the moment the shareholders' meeting is constituted until the moment debate on the corresponding item of the agenda has been declared open. Each entitled person may make a single speech on each item of the agenda. Henceforth, the Chairman has set the maximum duration of each speech to 5 minutes on each topic debated. In this way, all those entitled to do will have an adequate amount of time to speak and express their opinion, and the duration of the shareholders' meeting can be maintained within appropriate limit to respect all the attendees. Response speeches are not going to be permitted after the debate is closed. Only short declarations of voting intentions are permitted, and they will have a total duration of 2 minutes per subject. And he may reserve the right to decide on any specific request at the time. If amendments to the resolutions formulated by the board are proposed, or otherwise resolutions other than those formulated by the board resolutions will be voted on first, and only if the resolution is rejected will then further resolutions be put to the vote. Similarly, if points of order should be presented that have not been scheduled for discussion, if Chairman should decide to put them into vote, they will be voted first as formulated by Chairman, and only if rejected will the proposals of the attendees be put to the vote. And the proposals of the attendees will be put to the vote, starting with the proposal presented by those who represent the highest percentage. Only if the proposal put to vote is rejected, the next proposal will be put to vote. Also, requirements of civil law and the regulations of regulated markets are be complied with. Chairman, I therefore declare today's shareholders' meeting validly constituted in extraordinary session and suitable to resolve on the topic listed on the agenda. I would like to inform you that the company has received no requests for the agenda to be supplemented or new proposals of resolutions pursuant to the law and Article 126 bis of the Consolidated Law Financial Statement. Also, entitlement to vote of those present has been verified. I will still ask all the attendees to report any deficiencies in entitlement to vote or exclusion from voting, or the existence of any shareholders' agreements pursuant to the law, current regulations and bylaws. So none of the attendees have submitted any extra proposal. So Notary Marchetti we'll leave the floor to you. Thank you. July 21st, company held 1.127.250 treasury shares, equal to 0.03 share capital. According to the information in the shareholders register, shareholders in possession, directly or indirectly, of shares with voting rights that representing over 3% of the total shares issued were CDP SPA 30.1%, Romano Minozzi 4.29%. Company is aware of the following shareholders agreement published pursuant to law of the company's website. That is, shareholders agreement between CDP, State Grid Europe Limited and State Grid International Development Limited, also regarding Snam, pursuant to Article 122 of the CLF under 130 of issued regulations. Regarding the questions formulated during the shareholders meeting concerning both ordinary and extraordinary, will proceed as follows. Answers will be given after the conclusions of discussions of the agenda items and potentially after a short break, if any, needed to prepare responses in a systematic way. At the end of the responses, the proposals of the agenda item will be put to the vote. I would like to inform you that regarding the right to submit questions pursuant to Article 127, so no questions were received prior to shareholders meeting. I would like to remind you that the company has appointed Georgeson SRL, represented here by Veronica Vari, as the subject on whom those entitled might confer a proxy with voting instructions on all or some of the proposals on the agenda. I invite the representative to henceforth indicate for each vote number of shares for which it did not intend to participate in vote pursuant to Article 135 on the CLF, and to make the declaration required by the applicable law, in case which, provided the preconditions were met, he intended to vote against the instruction he had received. I would like to declare meeting open. Before proceeding to debate the extraordinary part of the agenda, I would like to inform you that reports of the Board of Directors containing the proposed resolutions have been filed at the headquarters of the company with Borsa Italiana SPA, published on the company website according to law. Also, they've been sent to those who submitted their request. Furthermore, they were a printed document containing aforementioned reports and demerger plan with a relating attachment were distributed at the entrance of the meeting room. As far as the agenda items, I propose to omit the reading of the aforementioned documentation. We will, however, read the resolution proposals. So the one agenda item, concerning the extraordinary item, plan for the reorganization of Snam's equity investment in Italgas SPA, and in particular approval of the plan for the partial and proportional demerger of Snam SPA, required and consequent resolutions. File containing the Board of Directors report and demerger plan with related attachment was submitted to the registered office Borsa Italiana SPA and published on company website June 30. File containing the aforementioned document was provided to you at the entrance today to the meetings room and sent to those who requested it. Furthermore, inform you that the demerger plan was filed Milan Business Register on July 1, and as per Article 2506, 10 and Quater of the Italian Civil Code, the beneficiary company's financial position was prepared on the day of its incorporation, namely June 1, 2016, and approved by ITG Holdings Board of Directors, and pursuant to the aforementioned article, the company has relied upon the financial statement ending on 31st of December 2015. Documents have been filed at the registered office on July 5, April 5, respectively. Furthermore, financial statements of Snam relative to the last 3 fiscal years were filed at the registered office and published on the internet site. Conditions persist to exercise the exemption From preparation of report of expert, we implemented the opinion of the control, risk and related parties as per Article 8 of the regulations for related party transactions adopted by CONSOB 2010. Article 6, the procedure governing transactions involving the interests of directors and statutory auditors and related party transactions approved by Snam SPA and subsequently amended. You will find also a copy of the following document that will be attached to the minutes in a single file A, the merger plan. Finally, I note that the Board of Directors informs you that no significant changes were recorded for the company's assets and liabilities between the date on which the plan was filed at the corporate headquarters and today's date. ITG Holding confirmed this information. And also, the beneficiary company will take the name Italgas SPA. Current Italgas SPA will be named Italgas Reti SPA. The headquarters will be relocated in Milan via Carlo Bo 11. Such resolutions will be submitted to extraordinary shareholders meeting for approval. So I would like to ask Notary Marchetti to proceed with the consent of those present to read the proposed resolution of the Board of Directors regarding the only item for today's extraordinary shareholders meeting to the completion of the operations to be carried out by shareholders. So, of course, the extraordinary meeting of the shareholders, having reviewed the merger plan attached minutes, having reviewed and approved the director's report attached, having found consensus on the overall transaction which defined the merger proposal, considering that the merger plan was recorded on the Milan Business Register as per Italian regulations, more in specific Article 2501 Ter 2501 Septis, subsection 1 of the Italian Civil Code, has recalled respectively by Article 2506 bis, resolves to approve the project for the partial proportional demerger of Snam in favor of ITG Holding SPA, to consequently reduce Snam's share capital to service the demerger in the amount of 961,181,518.44 with no cancellation of shares, thereby amending with effect as from the date on which the merger takes effect Article 5 of the company's article as follows. Share capital is of euro 2,735,670,475.5 divided into 3,500.638.294 shares without nominal value, to give a mandate to the legal representatives with sub-delegation powers and with the express power set forth in Article 1395 of the Italian Civil Code to enter into the merger agreement in compliance with the conditions provided for in the plan, and in any case in the context of completing all the transactions associated with the merger, to give mandate to legal representatives to amend the form of this resolution to accommodate changes required at the time of registration on the business register. I don't know whether anybody is submitting comment or considerations, otherwise we may move forward.
Chiedo all'ufficio di Presidenza se vi sono richieste da parte.
The requests from shareholders, no requests from shareholders are being submitted, so we may start voting. As far as the demerger plan, and in the bylaws of the beneficiary, we have indicated the full new name. We would like to invite the attendees not to be absent during voting procedures, and please put forward the deficiencies of entitlement to vote, if any. So, Chairman, we understand there's no update Nothing, no considerations were submitted, so voting is open.
Dovremmo chiudere il voto. Grazie.
Thank you so much. So this is the number of votes we have in favor: 2,446,951,615 shares. If you consider the entire capital, we have 69.9%. We didn't have any vote against this decision. In terms of abstentions, 551,559 shares. This accounts for 0.02% of the capital. So, Mr. President, the proposal has been approved with a vast majority. Thank you so much. Thank you so much. Now the vote is now over. This was the only point we had in today's agenda. We can now close the extraordinary part of this meeting. We can now open the ordinary part of the meeting itself. Of course, we are not going to repeat all of the information we shared with you at the beginning of these works. So once again, I do confirm the meeting is validly constituted also in the ordinary meeting. So we have once again one point in the ordinary meeting, the authorization to purchase shares. So I'm asking Mr. Marchetti to read this proposal of decision or resolution of the Board of Directors concerning, once again, the only point in the ordinary meeting today, together with all of the operations having to do with shareholders' participation. Thank you so much. Now, this is the proposal you have in our dossier. Basically, we would like to authorize, in compliance with the law, some purchase of shares. The maximum amount is 500 million euros. Maximum limit is 3.5% of the joint scope that's been underwritten and decided. So this follows the partial proportional demerger. So if this is approved by the shareholders meeting, of course. And now this has to be approved within 18 months after the entry into force of the demerger. Please note that purchase has to be carried out for a price that cannot be higher than 5% or lower than 5% of the reference price. Of course, I'm talking about the MTA price in every single session before every operation. So if the company wishes to pay these shares in compliance with the criteria we have in the market, and of course I'm referring to the TUF concerning the so-called support activity by concept, purchase price will be as per the market. Now, the market condition today is the following. Purchase price cannot be higher than the current price having to do with the independent price that you can find on the MTA. Third point, purchase operation will be carried out on MTA thanks to the specific regulations having to do with the markets managed by Borsa Italiana SPA. In this case, we will have some predetermined proposals of negotiations. All of this has to be in compliance with the content of this report. And then we have the board of directors and the president. I'm talking about the proxy and powers. This means we may have some internal specialists. They can also work at this jointly and with the discretionary powers. So this means they can take care of the purchase in full compliance with the current regulations, together with the authorizations we have just mentioned. So if the shares are under the ownership of the company, all of the rights will also be shared with many other shareholders. All of these shares will be included into the joint stock in order to calculate the quorum, which is what we need in order to make decisions. So also in this case, I see we have no specific requests or questions, Mr. President. So I think we can now have the vote for this only point concerning the authorization to purchase own treasury shares. And so those present are now invited to stay here into the room. And just like before, please state any condition, for example, exclusion from the vote. Once again, we have the same attendees we had in the extraordinary part of this meeting.
Grazie. Dunque, qui hanno votato.
Thank you very much. In this case, we have the following votes in favor. 69.45% of those having the total capital, 2,430,642. Against, 16,089,774 shares. This accounts for 0.46% of the joint stock. We have the following abstentions, 355,339 shares, which is 0.01% of the capital. Once again, Mr. President, the meeting voted in favor of this proposal. Thank you very much. I think we have no other item in our agenda. We can now close the meeting. It is now 10:30.